for a car is going to want the paint job to be, I guess, perfect. I mean, when you think about it there.
Absolutely.
So that could actually trigger an opportunity for remedy. And again, you said the option, if you were to win in such a contest, you can have the option of another car versus your money back.
Yes, and it's the consumer's choice.
Okay.
Most of my clients, no surprise, take the money.
Oh,
they want their money back because they want to go to a different type of vehicle.
I imagine once you have the lemon taste in your mouth, you could do that. Okay, I know you're working from a series of questions here, and that's fine, because what we're going to try to do is show these questions to our viewers. So I won't interrupt you again here. Go ahead if wherever you are.
Okay,
on the list
well, let me talk about a couple of different ways. So, a couple things people should know. So again, if your vehicle has required repair to the same defect 3 or more times,
okay,
then you may qualify for a lemon. What people don't know is all 3 of those repair attempts don't necessarily have to take place in that first year, 18,000 miles. So if a defect presented itself within that period, and the second time it was repaired, you were at 13 months or 20,000 miles, as long as that first defect occurs within that statutory period, you're still it's still in play.
You can reach back then to the initial, but it's got to be the same problem.
Right.
Okay.
Exactly. And again, the manufacturer is entitled to 3 repair attempts.
Okay.
However, that changes if the defect is such that it was something that could likely cause an accident or serious bodily injury. So, for example, to give you an example, if your brakes failed, and you brought the vehicle back in that first year, 18,000 miles, they fixed the problem. You're driving home a couple, days, weeks, whatever later, they fail again. Boom, that's a lemon, because that type of defect is one that the dealer only has one shot to fix something like that. Yeah. And then again, the third way, which doesn't happen as often, is if you have multiple different problems. And case law 6 to 8 is generally what the case law looks at in that first year or 18,000 miles. If you've got so many different problems that it's apparent that the overall manufacturer of the vehicle can be questioned, then you may qualify for a lemon.
Can you put a number on that, Bill? I mean,
8 seems to be kind of the magic number from the case law recently.
Yeah. Well, I mean, that seems reasonable. I mean, if you bring the thing back 8 times and it's still not going.
Yeah.
Okay. Any other? Again, we'll try to actually show our viewers these questions, but go ahead. I mean,
okay. Well, there's 2 other pieces of misinformation that people might want to be aware of. Is first of all, you can't always look to the dealer for advice on whether or not you have a lemon. If you have any questions about whether your vehicle is qualified under the lemon law, you should contact the consumer law officer and have them answer your questions. And a lot of people also think that they need to go through an arbitration process, or they're told they need to go through an arbitration process before they can bring a lemon law claim against the manufacturer. And that may or may not be true depending on the manufacturer. So in Ohio, as in most states, there are certain manufacturers who have worked with the Attorney General to put an arbitration process in place, and there are others for whom arbitration process is not necessary.
Okay.
And I don't know the list off the top of my head, but generally speaking, if the dealer says you have to go through arbitration, check it out. You may not have to.
You might not have to. That I guess I was going to ask you a question on that. I think you've already answered it, but I'll just say it in I'll restate it. But oftentimes in contract law, you're expected to exhaust your administrative remedies before you could proceed with litigation. It sounds kind of like that's what we're talking about. You've got to go, in certain cases, you've got to go through an arbitration before literally you could take the case and litigate. Is that correct?
That is correct. And again, it depends on your manufacturer. Most of the Asian vehicle manufacturers require arbitration. And we're in my office, and I'm sure other consumer lawyers' offices, we'll help people with that process.
Yeah.
And we'll file the papers, and we'll do what needs to be done. In my experience, it hasn't been a great result for the consumer.
Really?
I'm going to guess, I think I read some statistics where 90% of those cases are found in favor of the manufacturer.
I see.
But what's good about it is, first of all, it helps flush out all the details of the actual
Sure.
case. But the ruling of the arbitrator is not binding on the consumer. It is on the manufacturer. So if you're one of the lucky 10% where they come back and say, yeah, you're entitled to a new car, you're going to get it.
Yeah.
And if they say not, then you still have the
we still have the law to file. Well, that's good to know, because I'm sure a lot of our viewers would just assume, and maybe many of them watching you right now said, yeah, I went through all that and I didn't win. They were in the 90%, so I guess I was stuck with it, and then they got frustrated with it and traded it in, or, well, I suppose that's what most people do with them. Okay, anything else on the lemon law you want to?
Well, maybe the other question I get a lot is people are unsure if their car is a lemon. If they brought it in enough times, what the qualifications are. So on my website, we have a series of 5 questions that people can go through. And if they can answer yes to any of the 5, chances are pretty good that we can help them.
Okay.
We may not be able to get them a new vehicle in a particular case, but in some instances, we're able to represent them to the manufacturer, and we're able to do anything from helping them get an extended warranty, maybe what's called a component letter, where a manufacturer will say, even though the warranty is about to expire, will warrant this particular problem component, and that'll run out. Or cash compensation. Sometimes manufacturers will say, look, we don't think this vehicle qualifies as a lemon. However, we feel bad for Mr. and Mrs. Smith,
sure.
and obviously they're frustrated, want them to be happy. Here's X number of dollars.
That's kind of nice to know, because it not necessarily an all or nothing there. I mean,
right.
The dealers or the manufacturers are kind of willing to meet halfway in some areas.
They are.
Okay.
Yeah.
And again, there are these key questions you do show on your website.
Yeah.
And
we could take through those real quick if you don't mind.
Yeah, go right ahead. I mean, I think that's excellent idea.
Okay. Well, the first is, has the vehicle been in the shop 3 or 4 times or more for the same problem, which is kind of what we talked about. Has the vehicle been in the shop for 30 calendar days or more? And again,
what does that mean, Bill? I mean, you brought it there, you need it back for 30 days?
Right. It could be on one visit. It could be on
the aggregate
several visits. But if in that first year, 18,000 miles, your car is in the shop for 30 or more days, it qualifies as a lemon.
I see. That's interesting.
Mm-hmm. Has there been 6 or more repair attempts made to various problems, even if more than one repair was made, more than one defect, on one particular visit to the shop?
Wow.
So that's the one I talked about, where there's a lot of different
problems.
That's a lemon. Yeah. Those are often more frustrating for people, because it's a lot of different things, and the amount of time back and forth to the shop, etc. So, and when you have that number of problems, it's often the same cases where you run into that 30-day issue as well. Okay, next, has the vehicle been in the shop for a problem that was never fixed properly under the warranty, and it continues to exist now that the warranty has ended?
So here again, we could look back there, if it happened in that first year, 18,000 miles.
Right.
Albeit it manifests itself later, you still might have some opportunity there.
Sure.
Okay.
And the last one is, has the dealer and or manufacturer refused to make the repair or charge you for repair to a particular problem that should have been covered under the warranty? We don't see this too much in lemon law cases, but in breach of warranty cases, which are related,
sure.
which is basically what it says, a breach of the warranty. You bought a car, the manufacturer said, if this problem happens, we'll fix it, and sometimes either they can't or they don't. So even if it's outside the lemon law, there are some remedies for breach of warranty.
Go there. Mm-hmm. So that's the big 5, and
so again, a yes to any of those questions means you could probably benefit from retaining counsel to represent you in a lemon law claim.
And Bill, we're going to, it's very interesting. We're going to sort of shift gears here.
Sure.
But when did you say this came? I mean, what point in time, what year?
The lemon law?
Yeah.
My understanding is most came in the 70s. They were written
in the 70s.
Yeah,
okay.
And in Ohio, I think the Ohio law was first passed in '87.
Oh, okay.
And then it was revised again about 10 years ago in '99.
I see. So this is really revision in '99. That's pretty current legislation, and it's definitely alive and well, right?
It is.
So I guess
more so than the car industry.
Yeah, it's one of those things that sometimes if you're fortunate enough not to have these problems, and maybe it's not as much as I mentioned when I was a kid, where people talked about over the back fence, but serious situation. If you some car loans now go out 5-7 years and a significant amount of money, and the thought of being stuck with that thing, continuing having the same problems,